There's been a lot of chatter recently about whether or not states have the authority under the 14th Amendment of the U.S. Constitution to disqualify Donald J. Trump from appearing on the ballot as a presidential contender in the upcoming election. In this video, I'm going to explain to you why I believe that that is a complete non-starter. Let's have a look. So before I get into any case law or the Constitution itself, let's have a look at what Representative Adam Schiff had to say about this particular issue.
There's an argument circulating about whether the 14th Amendment that prohibits anyone, quote, engaged in insurrection or rebellion from holding public office bars Trump from running for president. Now, this hasn't been tested in our system before. Do you think, what is your thought on whether that's a valid argument?
I think it is a valid argument. The 14th Amendment, Section 3 is pretty clear. If you engage in acts of insurrection or rebellion against the government, or you give aid and comfort to those who do, you are disqualified from running. It doesn't require that you be convicted of insurrection. It just requires that you have engaged in these acts. It's a disqualification from holding office again, and it fits Donald Trump to a T. I think this will be tested when the Secretary of State either refuses to put him on the ballot or puts him on the ballot and is challenged by a litigant. I would imagine it will go up to the Supreme Court, and that's the big question mark through all of this, which is, what will the Supreme Court do? There are prominent constitutional scholars as well as prominent progressive scholars who believe that he should be disqualified. But will the court take that step? Ultimately, only time will tell, but I do think
So essentially, Adam Schiff is saying that he thinks it's potentially legitimate for the individual secretaries of state to independently determine whether or not Donald Trump can appear on the ballot because of the actions that he took during the January 6th insurrection. Now, you'll find that he said certain things like a conviction for essentially aiding the insurrection is not required. And we're going to have a look at whether or not that's the case, according to the plain text of the Constitution, as well as case law regarding the things similar to this particular issue. As Mr. Schiff did say, there is no case law directly on point because we haven't had to deal with this issue. The 14th Amendment was added to the Constitution in response to the Civil War and hasn't really been used since then. So there's a dearth of case law on this issue. But there is some case law out there that will give us some guidance as to what the court is likely going to decide on this particular issue. And I'm going to go over some of that case law with you. So with that, let's have a look at the text of the Constitution itself. So first, we're actually going to look at the 14th Amendment. The 14th Amendment says in Section 3, no person shall hold any office under the United States who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So first, we'll deal with that last sentence. The last sentence essentially says that Congress may, by a vote of 2/3, remove such disability. So it treats the person who aided in an insurrection or gave comfort to those during an insurrection as a disability that Congress can remove. And Congress has, in fact, removed that disability from insurrectionists during the Civil War. There was an entire act of Congress that essentially removed that, but that's not really germane to our consideration here. What is germane is that it is considered a disability. So the real crux of the issue is the part of this that says, shall have engaged in insurrection or rebellion or given aid or comfort. Once there is a determination that someone has engaged in an insurrection or rebellion or given aid or comfort, well, then they are disqualified from holding the office of president if they satisfy these other conditions, which Donald Trump obviously satisfies. The question is, who gets to make that determination? Is it the states? Is a criminal conviction required? Who essentially is it? Is it Congress? Because Congress can remove the disability. Can they put the disability there in the first place? And answering that question is really going to answer whether or not we should even be dealing with this issue at this stage of the presidential election season. So to help us answer that question, let's look at a couple other areas of the Constitution that may shed some light on this. So in other areas, there are qualifications for the president that there are Supreme Court cases that say that secretaries of state can determine whether these qualifications are met and remove a person from the ballot or not allow them to appear on the ballot if these qualifications aren't met. So Article 2, Section 1 says, no person except a natural born citizen shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years. So, of course, that brings to mind John McCain and the fact that he was born in the Panama Canal Zone. Obviously, he was allowed to be on the presidential election ballot, even though there were challenges to whether or not he was a natural born citizen because he was born in the Panama Canal Zone. Of course, it also brings to mind Barack Obama's citizenship given the entire birther debate. And we're going to have a look at a case regarding that. Article 1, Section 3, potentially. Now, I use the word potentially because the Supreme Court has not determined this to be the case, but they have allowed for it to possibly be the case. Article 1, Section 3 gives another potential qualification for the office of President, Senate, House of Representatives, all those offices. And it says, this is dealing with the impeachment power of the Senate. It says that judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So basically, once someone has been convicted of an impeachable offense, well, that bars them from holding any further office under the United States government. So had Donald Trump been convicted of an impeachable offense by the Senate, which he was not, then he would be disqualified from holding the office of president in the future. So the argument there is, well, this particular section requires a conviction. And so that is likely why Representative Schiff is saying that under Amendment 14, no conviction is required. But we're going to see that that's not necessarily the case. Finally, we have the 20th Amendment. Now, under the 20th Amendment, this is the Constitution essentially gives the final determination of who is going to become president to the Senate and the House of Representatives. And when they're on January 6th, during that insurrection, this is exactly what they were doing. They were essentially opening all of these things from all of the states that say, here's how we vote for the president. And they were determining whether or not those votes were good. And one of the things that they're allowed to do during that process is raise objections to a candidate taking the office of president or raising objections to the process, things of that nature. And they are able to determine whether or not a candidate qualifies for the office of president. In fact, here they have the statement, if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified. So essentially, there is room within the Constitution for a candidate to get the required votes necessary to become president, but still not qualify to hold the office. And in such case, the vice president-elect becomes the president, and then until a president qualifies. So essentially, the final determination as to whether or not there are a candidate meets the qualifications for a president is not necessarily held by the Secretaries of State. And in fact, the Constitution makes allowance for that. It makes allowance for the Secretaries of State to permit people to appear on the ballot, and then for Congress to determine that those people are not qualified to hold the office. So this is a bit of a murky area of the law because there are these multiple areas of the Constitution that affect the determination on this. But we're going to look at a seminal case out of the United States Supreme Court. This is U.S. Term Limits v. Thornton. Essentially, the state of Arkansas attempted to put term limits in place for members of Congress. And this is the Supreme Court's decision as to whether or not that was constitutionally acceptable. So I'm going to read a few excerpts so that you can get an understanding of what the U.S. Supreme Court decided here. They said, today's case presents a challenge to an amendment to the Arkansas state constitution that prohibits the name of an otherwise eligible candidate for Congress from appearing on the general election ballot if that candidate has already served 3 terms in the House of Representatives or 2 terms in the Senate. So they were Arkansas was trying to term limit its senators and representatives. A lot of this we don't need to get into, but so I'm only going to read a few excerpts from this lengthy opinion. As the opinions of the Arkansas Supreme Court suggest, the constitutionality of Amendment 73, that's the amendment to the Arkansas Constitution, depends critically on the resolution of 2 distinct issues. The first is whether the Constitution forbids states to add to or alter the qualifications specifically enumerated in the Constitution. The second is, if the Constitution does so forbid, whether the fact that Amendment 73 is formulated as a ballot access restriction rather than as an outright disqualification is of constitutional significance. Our resolution of these 2 issues draws upon our prior resolution of a related but distinct issue, whether Congress has the power to add or alter the qualifications of its members. So essentially, they're going to look at whether Congress even has the power to change the qualifications in order to determine whether the states have the power to change the qualifications. So they go on. In Powell v. McCormick, we reviewed the history and text of the qualifications clauses. So here, in this footnote here, the qualifications clause are much like the qualifications for president clause. In Article 1 of the Constitution, they give the qualifications for members of Congress. They're very similar to the qualifications for president, but they add to those qualifications the possibility that an impeachment is a qualification. And they add that the 14th Amendment may also act as a disqualification, but they don't make a determination as to whether that's the case, because the case that they are dealing with doesn't require them to make that determination. So that's why I read those excerpts of the Constitution for you, because there may be, like I said, additional qualifications other than those specifically enumerated in the original text of the Constitution by the amendments to the Constitution. Moving on, in Powell v. McCormick, the principal issue was whether the power granted to each house in Article 1, Section 5 to judge the qualifications of its own members includes the power to impose qualifications other than those set forth in the text of the Constitution. In an opinion by Chief Justice Warren for 8 members of the court, we held that it does not. So Congress does not have the power to add to its own qualifications for members of that body. They distinguish that from the power to exclude they distinguish the power to exclude from the power to impose qualifications. So here they were dealing with whether or not in Powell v. McCormick, whether or not during the seating of a member of Congress, they could say, well, we're not going to seat you because you don't meet the qualifications that we have arbitrarily imposed, as distinct from whether or not during the course of and after seating a member of Congress, during the course of their term in Congress, the members can kick that congressperson out, which they can do. And there are no real limits on their authority to do so. But that person can just be elected again in the special election that would occur after they're kicked out of Congress, and Congress would have no ability to undo that special election. Moving on, we thus conclude now, as we did in Powell, that history shows that, with respect to Congress, the framers intended the Constitution to establish fixed qualifications. Second, we recognized the critical postulate that sovereignty is vested in the people, and that sovereignty confers on the people the right to choose freely their representatives to the national government. So essentially, because the Constitution gives the people the right to directly elect their senators and representatives, abridging that right is violative of the Constitution, and the abridgment of that right would come in the form of adding qualifications to an otherwise qualified candidate. So here, petitioners argue that the Constitution contains no express prohibition against state-added qualifications, and that Amendment 73 is therefore an appropriate exercise of a state's reserved power to place additional restrictions on the choices that its own voters may make. We disagree for 2 independent reasons. First, we conclude that the power to add qualifications is not within the original powers of the states, and thus is not reserved by the state to the states by the 10th Amendment. Second, even if states possessed some original power in this area, we conclude that the framers intended the Constitution to be the exclusive source of qualifications for members of Congress, and that the framers thereby divested states of any power to add qualifications. So essentially, the states do not have the power under the 10th Amendment, which reserves powers to the state, to add qualifications, because members of Congress were a thing that was created by the Constitution itself. Therefore, it couldn't have been something that the states already had. The power to send members to Congress or to make qualifications for members of Congress could not be a power the states had if Congress didn't exist before the Constitution existed. So here they move on. Contrary to petitioners' assertions, the power to add qualifications is not part of the original powers of sovereignty that the 10th Amendment reserved to the states. Petitioners' 10th Amendment argument misconceives the nature of the right at issue because the amendment could only reserve that which existed before. As Justice Story recognized, the states can exercise no powers whatsoever which exclusively sprung out of the existence of the national government, which the Constitution does not delegate to them. No state can say that it has reserved what it never possessed. So because Congress sprang out of the Constitution itself, then the states couldn't have had that right reserved to them. Similarly, the office of the president sprang out of the Constitution whole cloth. So a similar argument exists with respect to the president. The states do not have the power to impose additional qualifications on the office of president or on candidates for the office of president that do not exist in the Constitution itself because they never had that power before the Constitution existed. So any power that they do have must come directly from the Constitution. There is no clause in the Constitution that allows them to make new qualifications for the office of president. Moving on, with respect to setting qualifications for service in Congress, no such right existed before the Constitution was ratified. Representatives and senators are as much officers of the entire union as is the president. And this is very important, which is why it's highlighted in red. States thus have just as much right and no more to prescribe new qualifications for a representative as they have for a president. It is no original prerogative of state power to appoint a representative, a senator, or president for the union. So, states do not have the power to create new rights for new qualifications for the office of president, as the Supreme Court has already decided. So the question becomes, is the determination of whether or not someone has engaged in an insurrection or given aid and comfort to those who have engaged in an insurrection the creation of a new qualification? My take is that it is. So if the states are able to individually determine, based on their own criteria that they've made up whole cloth, whether or not someone has engaged in an insurrection or given aid and comfort to those who have engaged in an insurrection, then the states are thereby putting their own qualification system, their subjective view on what it means to engage in an insurrection or give aid and comfort to those who are engaged in an insurrection onto the office of president, thereby creating a brand new qualification that another state might disagree with. And it's that creates the problem for a Secretary of State to come in and say, well, Donald Trump engaged in an insurrection, so he can't be on the ballot here. Or Donald Trump gave aid and comfort to those who engaged in an insurrection, so he can't be on the ballot here. If there is no criminal conviction, and mind you, there are statutes in place regarding treasonous acts, insurrection, things of that nature. There are federal statutes in place. So Donald Trump can be charged criminally for the very things that the 14th Amendment is saying act as a qualification for president. Unless Donald Trump is convicted criminally in a federal cause of action for any one of those things, then the states themselves are making up qualifications in a civil action for something that has a remedy in a criminal action, and they can't do that. The court here goes on and says any state power to set the qualifications for membership in Congress must derive not from the reserved powers of state sovereignty, but rather from the delegated powers of national sovereignty. In the absence of any constitutional delegation to the states of power to add qualifications to those enumerated in the Constitution, such power does not exist. So there is a portion of this decision that gives some wiggle room here for the states, but there's another decision in another case that takes that wiggle room away. So we're going to look at the wiggle room. The court goes on to say, similarly, we believe that state-imposed qualifications, as much as congressionally imposed qualifications, would undermine the second critical idea recognized in Powell, that an aspect of sovereignty is the right of the people to vote for whom they wish. So essentially, the states are taking away the right of the people to vote for whom they wish if they remove Donald Trump from the ballot. But, and this is where the wiggle room comes in, finally, state-imposed restrictions, unlike the congressionally imposed restrictions at issue in Powell, violate a third idea central to this basic principle, that the right to choose representatives belongs not to the states, but to the people. Now, to understand why I say that this is a bit of wiggle room, you have to understand that how we elect a president. So a president isn't elected by the direct vote of the constituents. The constituents essentially have no say in who becomes president. So I have no say in who becomes president. The way the Constitution is set up, the states appoint people to elect the president. So unlike here in U.S. term limits v. Thornton, where they're talking about congressional elections, which constitutionally are by direct choice of the constituency, the state's power to appoint electors for the president essentially gives the states the authority to directly elect the president. So if that's the case, then the right to choose that the Powell decision was talking about isn't held by the people at all. So restricting the access of Donald Trump to the ballot would then be okay because the people don't get to choose who the president is anyway. But as we'll see in another case, that's not necessarily the case. So a lot of us probably remember when Al Gore and George Bush, the second George Bush, were running against each other, and the debacle that occurred down in Florida. That led to a decision out of the Supreme Court called Bush v. Gore. And this is one excerpt from that decision. The individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as a means to implement its power to appoint members of the Electoral College. This is the source for the statement in McPherson v. Blacker that the state legislature's power to select the manner of appointing electors is plenary. It may, if it so chooses, select the electors itself, which indeed was the manner used by state legislatures in several states for many years after the framing of our Constitution. History has now favored the voter, and in each of the several states, the citizens themselves vote for presidential electors. So we don't vote for the president, we vote for the electors, and then the various state legislatures have enacted laws that say once those electors are voted for by the people, how the electors have to cast their votes for the president. Some of those a lot of them vary, but in many states, it's proportional to the number of votes that the people cast for the individual candidate. So essentially, the electors have to vote in proportion to the population vote. When the state legislature vests the right to vote for president in its people, the right to vote as the legislature has prescribed is fundamental. And one source of its fundamental nature lies in the equal weight accorded to each vote and the equal dignity accorded to each voter. The state, of course, after granting the franchise to in the special context of Article 2, can take back the power to appoint electors. And they're going to quote here from McPherson v. Blacker and say, there is no doubt of the right of the legislature to resume the power at any time, for it can neither be taken away nor abdicated. So essentially, the legislature can enact a new law that says, well, we're discarding that other thing where we gave the right to the people, and we're taking the right back. But until the legislature does that, according to Bush v. Gore, the people have a fundamental right to choose the electors, and where the electors are under the state statutes at issue, are then required to voice the will of the people through their vote for the president, well then essentially the state has given the electors the people the ability to kind of vote for the president. So if we're then going to take away a candidate from appearing on the ballot, then we're taking away the people's ability to require their electors to vote for that candidate when they cast their votes for the president. And based on U.S. term limits v. Thornton, the states cannot impose additional requirements, additional qualifications on a candidate for president than those that appear in the text of the Constitution. So again, the question becomes, well, does the text of the Constitution say definitively whether or not Trump is not qualified to be a candidate? Because that is the determining factor in every case that has been decided regarding qualifications. So there have been a few times the secretaries of state have looked at the qualifications of president and either allowed somebody to be on the ballot based on the qualifications or removed them from the ballot based on the qualifications. But those qualifications are independently ascertainable. So as we read, the qualifications for president are natural born citizenship and age. And we can look at somebody's birth certificate and determine whether or not they're a natural born citizen. We can look at their birth certificate and determine their age, so they're independently ascertainable. If other work has to be done, however, in order to determine whether this particular section of the Constitution applies, well then it's no longer independently ascertainable as to whether or not the qualification has been met. And the Constitution doesn't give the states the ability to make that determination arbitrarily. Otherwise, it would be utter chaos. Donald Trump would be able to appear in some states and not others. There'd be a multitude of challenges to whether or not he can appear on the ballot. It's an unworkable system. Every time we have a presidential election, people would be saying this person doesn't qualify under the 14th Amendment, and we'd have just a deluge of cases in our federal court system trying to get people removed from the ballot. So let's look at how courts have dealt with issues of qualifications in the past. So first, we're going to have a look at a case called Keys v. Bowen. In this case, this is out of a California state court. They write that the presidential nominating process is not subject to each of the 50 states' election officials independently deciding whether a presidential nominee is qualified, as this could lead to chaotic results. Were the courts of 50 states at liberty to issue injunctions restricting certification of duly elected presidential electors, the result could be conflicting rulings and delayed transition of power in derogation of statutory and constitutional deadlines. Any investigation of eligibility is best left to each party, which presumably will conduct the appropriate background check or risk that its nominee's election will be derailed by an objection in Congress, which is authorized to entertain and resolve the validity of objections following the submission of electoral votes. And that can be found at United States Code Section 15. The counting of electoral votes in Congress and the process for objecting to them is detailed in Section 15 of Title III of the United States Code, which provides in relevant part, the votes having been ascertained and counted according to the rules in the subchapter provided, the results of the same shall be delivered to the President of the Senate, who shall thereupon announce the state of the vote, which announcement shall be deemed a sufficient declaration of the persons, if any, elected President and Vice President of the United States, and, together with a list of the votes, be entered on the journals of the two houses. Upon such reading of any such certificate or paper, the President of the Senate shall call for objections, if any. Every objection shall be made in writing and shall state clearly and concisely and without argument the ground thereof, and shall be signed by at least one senator and one member of the House of Representatives before the same shall be received. When all objections so made to any vote or paper from a state shall have been received and read, the Senate shall thereupon withdraw, and such objections shall be submitted to the Senate for its decision, and the Speaker of the House of Representatives shall, in like manner, submit such objections to the House of Representatives for its decision. So essentially, this California court is saying, look, we've already got a process for this. There's a process for determining whether or not somebody's qualified. It's outlined in the United States Code. That's what Congress established to do this. We can't come in and say, and require our secretaries of states to say, this person is or is not qualified, because what if they get it wrong? We'd have so many problems in having a system that does it any other way, that it needs to be done this way. They go on. Indeed, in a case very similar to this one, the United States District Court of the Northern District of California dismissed a challenge to John McCain's citizenship, holding that presidential qualification issues are best resolved in Congress. That case is Robinson v. Bowen. You can see the citation here if you want to look it up. Thus, mechanisms exist under the 12th Amendment and the United States Code for any challenge to a candidate to be ventilated when electoral votes are counted, and that the 20th Amendment provides guidance regarding how to proceed if a president-elect shall have failed to qualify. We read that amendment. Remember, Congress has, or the people have already decided how we are going to ventilate the issues of whether or not, or what to do whenever a presidential candidate fails to qualify, even though they got the requisite votes necessary to become president. Issues regarding qualifications for president are quintessentially suited to the foregoing process. Arguments concerning qualifications or lack thereof can be laid before the voting public before the election, and once the election is over, can be raised as objections as the electoral votes are counted in Congress. The members of the Senate and House of Representatives are well qualified to adjudicate any objections to ballots for allegedly unqualified candidates. Therefore, this order holds that the challenge presented by plaintiff is committed under the Constitution to the electors and the legislative branch, at least in the first instance. Judicial review, if any, should occur only after the electoral and congressional processes have run their course. So, what this court is saying is, look, there's a process. Follow the process and all of this will resolve itself. We're not going to come in and second guess the process that already exists because chaos would be the result. So the answer to that, according to people who have looked at this issue, is, well, that's not always the case. Sometimes the states are allowed to determine whether or not a candidate meets the qualifications. So let's look at a couple of those cases. So first, we have the one that is cited the majority of the time because it's authored by a current Supreme Court Justice, Neil Gorsuch. So this case is Hassan v. Colorado. This is out of the 10th Circuit Court of Appeals, and this decision came down before he became a Supreme Court Justice, obviously, but it is penned by Neil Gorsuch, as you can see here. Abdul Karim Hassan is a naturalized citizen who wishes to run for the presidency of the United States. So when the court starts with the first sentence stating why this person is not qualified, it tells you something. It tells you, well, nobody is disputing whether or not this person is qualified. Right? So that's going to be the theme here. When nobody is disputing whether or not the person is qualified, then it's okay for the Secretary of State to make the determination that this person is not qualified. After the Colorado Secretary of State informed him that his ineligibility for office precluded his placement on the ballot, Mr. Hassan brought this suit asserting that the natural-born citizen requirement and its enforcement through state law barring his access to the ballot violates the citizenship, privileges, and immunities and equal protection clauses of the 14th Amendment. So essentially, what this guy's arguing is that the amendments to the Constitution supersede the Constitution. So the Equal Protection Amendment basically changed the qualifications for president because it didn't apply equally to all citizens. So the court said, just no, that's not the case. But let's move on. Gorsuch writes, even if Article 2 properly holds him ineligible to assume the office of president, Mr. Hassan claims it was still an unlawful act of discrimination for the state to deny him a place on the ballot. So, he's kind of arguing, well, I should have still been on the ballot because maybe everybody would have voted for me, and then it would have went to Congress, and Congress would have had to disqualify me. So Gorsuch is going to deal with that. But as the magistrate judge's opinion makes clear, and we expressly reaffirm here, a state's legitimate interest in protecting the integrity and practical functioning of the political process permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. So that's the portion of this decision that everybody likes to cite and say, well, Gorsuch has already said that a state has a legitimate interest in excluding people from the ballot who are constitutionally infirm. The problem is, that's not really what Gorsuch said. He said the state's legitimate interest in protecting the integrity of the political process allows them to do that when it is 100% clear, when there is no debate over whether or not the person is constitutionally prohibited from assuming office. He said nothing about where there is a situation that we find ourselves in now, which is, well, there is some debate, a lot of debate over whether or not Donald Trump is permitted under the Constitution to assume the office of president. So in that case, the state doesn't have the authority to just arbitrarily make stuff up. It can't create its own new qualification based upon its opinion of what it means to commit an act of insurrection or give aid and comfort to those who are engaged in insurrection. States don't have that power. That is the creation of a new qualification for president. It doesn't matter how you parse it. Without the criminal conviction, if a state makes that decision, they are necessarily creating a new qualification for president. Let's look at another case. So here, this is McInish v. Bennett. This is an Alabama case, and this is regarding Obama's citizenship. Chief Justice Moore wrote the dissenting opinion in this case. So the reference to Chief Justice Moore is with respect to his dissent. Chief Justice Moore would impose upon the Secretary of State a duty to investigate the qualifications of all presidential candidates. However, Chief Justice Moore has failed to demonstrate how the Secretary of State, a non-judicial officer with no subpoena power or investigative authority, could carry out this duty in those cases where an actual dispute arises regarding a candidate's qualifications. Or, as in this case, could demand delivery to her of a certified copy of a candidate's birth certificate from the official records depository in another state in which the birth certificate is kept. So, even when it comes to something that there is documentary evidence of, the Secretary of State's lack of any power to force anyone to give them a copy of that, or with any power to investigate whether or not this qualification has been met, you can't force a Secretary of State, is what he's saying, to take that duty that they don't have the power to take. So you can't require, which is what the litigant here was trying to do, you can't require the Secretary of State to make sure that all candidates are qualified. In much the same way, though, where there is any dispute over whether or not a candidate is qualified to hold the office, the state is without authority to say that they are disqualified from holding that office because there's a dispute. And they don't get to be the arbiters of such disputes. The Constitution does not give them that authority. Chief Justice Morris cited cases in which federal district courts have upheld decisions of state officials, including secretaries of state, who had refused to qualify proposed candidates who were less than 35 years old. However, in each of those cases, there was no real dispute as to the candidates' qualifications because both candidates conceded they did not satisfy the age requirement of Article 2, Section 1 of the U.S. Constitution. Therefore, there was no need for the Secretary of State to affirmatively investigate the matter of the candidates' qualifications. So, again, you can't have states investigating whether or not somebody fits the qualifications of a president, and even if you could, where there is no objective criteria by which to determine whether that person has met the qualifications to hold the office of president, the states have nothing to investigate. So again, unless and until Donald Trump is convicted of having engaged in insurrection or given aid and comfort to those who have engaged in an insurrection, there's nothing for any individual state to look at and say, all right, this document right here or this court decision right here says that it was proven beyond a reasonable doubt that Donald Trump engaged in insurrection or gave aid and comfort to those who were engaging in an insurrection, and therefore he is unqualified to hold the office, and therefore we can exclude him from the ballot. Without that, it's really arbitrary. So the court in this particular case went on to say, under our current structure, the burden of investigating a presidential candidate's qualifications is best left, unfortunately or not, to that candidate's particular party, which is aptly stated in Keyes, is presumed to conduct a thorough investigation of the candidate's qualifications or risk a challenge to that candidate's candidacy in Congress, the appropriate forum for a post-election challenge to a president's qualifications. So again, the decisions are pointing back to Congress being the forum to challenge candidates' qualifications for holding the office of president. The state's job is to gather the people's choice for who is going to hold the office of president. Congress's job is to determine whether the people's choice meets the qualifications for that office. The only time a state can determine whether or not a person can appear on the ballot because of a qualification issue is when it is indisputable. When there is no dispute over whether or not that candidate can assume the office of president. As it stands right now, there is great dispute over whether or not Donald Trump can hold the office of president. Therefore, states cannot decide on their own whether or not to put him on the ballot. They must put him on the ballot. They have no choice. If he meets all the other criteria, which he does, and he goes through all of the paperwork necessary to get on the ballot, they have no choice but to put him on there. Any other opinion, in my view, is foolish. But let me know what you think in the comments below. For now, my name is Nathan Saunders, and this is The Legal Good.